That brings us to the second big indemnity that you see in contracts about information technology, and that's the data breach indemnity. And I say second big indemnity because it's very often negotiated, not because it's granted anywhere near as often as the IP indemnity. Vendors are very hesitant to give data breach indemnities for some reasons I'll explain. And the key difference between the data breach indemnity and the IP indemnity gets back to that issue of blame that I mentioned at the start of this chapter, start of talking about indemnities. So the IP indemnity applies without reference to blame. It's a lawsuit against the customer for using the vendor's technology. Doesn't matter whether the lawsuit's valid or not, doesn't matter whether the vendor's product actually does infringe, the vendor under typical terms will defend. Almost no vendor is going to do that with a data indemnity. In theory, you could write a parallel indemnity that says if there's a data incident, data breach, leak, hacking, whatever from the vendor's computers, and the customer's data gets access, cloud system, customer's data is on the vendor's computer, the vendor will defend. But the vendor won't do that in almost any case that I've seen, because they know that the data breach could result from the customer's screw up. The customer could leave a laptop running in an airport. The customer could do a bad job protecting passwords. In other words, it's not as clear that the data breach is the vendor's problem, it's about the vendor's business, as it is with the IP type claim. And so you're going to get vendors doing something that I just told you is problematic, which is they'll say something like, we will give you a data breach indemnity covering any claims resulting from our breach of contract. So if they breached the contract and that led to the data breach, they'll cover the claims. Or covering any claims, maybe they'll make it more narrow, covering any claims related to our violation of applicable privacy law. So what that means is if there is a data incident and third parties, injured consumers, government agencies, whoever sue the customer, vendor's only covering it if the claim resulted from the vendor's breach or other mistake. And vendors, you should be doing this. You shouldn't take on, if you can avoid it, the risk of handling any indemnity claim related to your customer's screw up or something that you were completely innocent about. But this creates some problems. I'm going to explain the problems that arise when you break that rule about an indemnity that isn't triggered by blame. Quick note though, before we go into that, you could also see this indemnity go both ways. Sometimes the vendor says you could cause the data breach, we're going to indemnify you against claims related to data breaches that we caused or result from our breach, and you're going to indemnify us about claims related to data breaches that you caused. And this is not unusual. You might see vendors who are looking for this from their customer. Either way, we've got quite a problem here. And I'm not going to go into it in great detail. I just mostly want to make you aware of what a mess we get in an indemnity that is triggered by one party's wrongdoing. The problem starts with this. You might think, okay, so if we were in the wrong, we'll indemnify you. It's simple enough. What if at the beginning of the case, what if there's a data incident and a bunch of third parties, maybe a class action, sue the customer, customer turns to the vendor and say, you defend this, you got a data breach indemnity, and the vendor says, no, the indemnity says we defend, we indemnify you if we caused the data breach or we breached the contract in a way that led to the data incident, and we didn't. And the customer says, yes, you did. The two parties disagree. What happens now? Well, you might think the answer is that the court will resolve it, and then everybody can move along with a decision from the court. But the court's probably in this lawsuit not going to determine who was at fault until the end. The defense comes at the beginning. We may be years away from a decision of the court on this. So the parties are fighting each other about whether the indemnity applies. They're probably, first problem, creating a record that the plaintiff, the third party suing one or both of them, loves. Each one's accusing the other. That's great. We know somebody's liable. We've got both defendants on the record saying somebody did something wrong. There's also all kinds of problems. So from the vendor indemnitor's point of view, do we defend this case? If we don't, and the customer defends it badly, and then the court holds the breach as we caused the breach, we'd have to pay a judgment we might have avoided if we had defended it. Do we pay settlements? Does the customer pay settlements when then they have to go after the other party? And there's an even worse problem for the vendor. And I'm really just briefly summarizing this because it gets so complicated. There's a common law principle I call the duty to defend law in many jurisdictions that says, if there's any doubt about a factual question, about whether the indemnity applies, not a legal question, factual question like who caused the data incident, the indemnitor has to defend until that's resolved. So the vendor could find itself, you thought you did a good job drafting a clause that says you're not on the hook, but in fact, you have to defend the case until a court holds you didn't cause the data breach, possibly years of defense. And it gets worse than that. The customer is accusing you of causing the data breach. You're hiring a lawyer to accuse you, and you're accusing the customer. You may have to hire 2 law firms and pay them to fight each other because you took on this indemnity. This gets really complicated. If you want to get into the intricacies of this hard issue, which I call advanced indemnities, read subchapter 5 in the indemnities chapter in my book, The Tech Contracts Handbook. It goes through this in some detail. You don't actually need to follow all the intricacies I've just explained. If you come out of it understanding that a data breach indemnity gets really, really messy, and because of this, element of blame, then you're in good shape. And the question is then, what do you do? What do we do about data breach indemnities given this problem? And I think, if you've negotiated many of these deals, you know what the answer is. A lot of tech vendors just won't give a data breach indemnity, either because they're aware of this or they just know that this is scary. There is no data breach indemnity. Some will give the data breach indemnity, but they might limit it in very sort of strict artificial ways. Like they'll say, we have no obligation to spend more than X. They'll put some kind of limit of liability on the data breach indemnity obligation so that after, maybe it's unreasonable, maybe it's complicated, but their obligation to defend ends at spending, I don't know, $1 million. Some will try and make it better through an indemnity going both ways. If we're going to have this messy problem on our hands, you will too, customer. If we're each accusing each other, we're each going to have this problem. So it may be much harder to get what seems to you, if you're the customer, like a reasonable indemnity on data breach than it is on intellectual property. Keep one thing in mind. If you don't get an indemnity for data breach, or you don't get a strong one, don't fall into the common trap of saying, well, then we have no protection. That's not what it means. You probably have a data management and security clause. And if they breach that clause and it causes you an injury, they're liable under the contract. This isn't about whether they have any responsibility or liability. This is about whether they have an obligation to defend a third-party lawsuit. So long story short, data breach indemnities are hard. They get very complicated. And if you want to learn more, I do recommend that subchapter in my book. All right, I want to finish indemnities by talking briefly about other types of indemnity that you might see in technology contracts. IP indemnity is the most common. Data breach is probably at least negotiated or discussed almost as often, if not granted. Personal injury or property damage indemnity. It's usually one party saying, if your employee gets injured in our factory, we'll defend if there's a lawsuit by that employee, or your visitor gets injured in our factory, or our employee sexually harasses your employee. By the way, there can be an element of blame in this too. It can be the indemnitor is the party whose employees sexually harassed the other party and sexually harassed the other party's employee, and then the other party's employee sues that person's employer. And you might say, well, that's like the data breach indemnity. It's triggered by blame. It is. It raises all the same problems, but people are much more familiar with personal injury indemnities. They don't generally involve as high a liability. It's usually clearer and easier to figure out who's at least likely to be at fault than in a complex forensics examination of a data breach. So all that trouble I just explained to you about the cause problem exists, but is much easier to resolve. And so you do see these indemnities. Employment compensation and liability indemnity. This comes up in professional services relationships. So not so often in a cloud services or AI deal, but it might make sense if you have implementation services as part of your deal. You have humans building, creating, doing tech support. It's possible that that some contractor or employee of the vendor will be unhappy with compensation received or benefits received or not received and sue the customer because they think they have a right to, they say, well, we were effectively working for the customer. This indemnity says if one of our people, vendor is saying, if one of our people sues you for compensation or benefits, including contractors, we're going to defend that case and pay settlements or judgments. A reasonable ask. Distributor product liability. That's where one party puts its product into a distributor's larger product. The distributor will usually defend cases about product liability. We may see indemnities more and more about harm caused by outputs from machine learning AI systems. I told you about how unpredictable those outputs are. We may see some tech vendors saying to their customers, if you create an output using our system and it causes harm to someone and we get sued over that, we want you to defend us. I think this is going to be quite a battle. A lot of customers will say, no, if it causes harm, it's because your system did a bad job creating the output. And the vendor will say, no, it is not, because our system, everybody knows you don't know what's going to come out of an AI system. It's use at your own risk and you chose to use it. So there's a debate about whether such an indemnity makes sense, but I think we might see them. Going forward, the way I look at it is this. If you are particularly worried about a lawsuit from a third party as a result of the other party's actions, the other party's business, that's a good candidate for an indemnity. You're not doing it in most cases because you want a remedy, you want to retaliate against the other party for this thing. You're doing it because you agree, and hopefully the other party agree, this is really about your business. So you should defend this case, and you should pay any settlements, and you should pay any judgments. That's the concept of an indemnity. And if you're looking for one to protect you, that's the direction to look.
If you found this video useful, please come check out Tech Contracts Academy. We provide training on drafting and negotiating contracts about artificial intelligence, cloud computing, and other forms of software. It's all for lawyers, contract managers, and any business people involved with contracts. So please come check out our programs live and on demand at techcontracts.com.